Okay, let's go ahead and get started. So our third panel today will address the adjudication of intellectual property disputes by boards created by Congress within the U.S. Patent and Trademark Office and the Library of Congress. So while the Trademark Trial and Appeal Board has long existed, Congress passed legislation we've been talking about today in the American Vents Act, creating the Patent Trial Appeal Board in just 2011. Which actually just replaced the Board of Patent Appeals and Interferences, but ended up being very different. And then even more recently, just in 2020, Congress created the Copyright Claims Board. So this panel is going to discuss why these boards exist, how adjudication and disputes before these boards differs from litigation before courts, and what the future may hold with respect to these boards. So to moderate this panel, we're going to welcome one of SMU's adjunct professors, Mike Pegues. Mike is a partner at Polsinelli here in Dallas. He serves as the chair of the firm's intellectual property litigation practice, and he draws upon 30 years of experience in patent litigation to advocate on behalf of his clients. He earned his undergraduate degree in mechanical engineering from SMU before going somewhere else for law school. Mike.
Thank you, David. And I don't think I've been practicing for 30 years, but it's been a little while, so we'll go with that. But this panel will be interactive, so if you guys have questions as we go along, just raise your hand and we'll recognize you and ask the question. I noticed that, there's a propensity to sit in the back of the room. We will not call on you if you don't raise your hand, Mark Hubbard, but we see you back there. So I'll start off with my panel, and I'll start off with Judge Lynch. So Judge Lynch is the Deputy Chief Administrative Patent Judge at the TTAB, and she's been there for about 9 years, and I'll let her introduce herself to you all.
Okay, thank you, and I want to say thanks to SMU for having me here, and also congratulations on the anniversary of the symposium. I have been at my board for about 8 or 9 years, but I'm an even longer time U.S. Patent and Trademark Office employee. I've been there since 2001. So my position before the one that I'm in now was overseeing the Trademark Policy and Petitions Office. So the office that would put out trademark rules, the trademark manual of examining procedure that our examining attorneys use to apply the law when they examine trademark applications. And we handled various other things for the Commissioner of Trademarks. And I spent about 9 years in that role. Prior to that, I started with the USPTO in our solicitor's office. So I've kind of come full circle because my first job at the agency was defending at the Court of Appeals for the Federal Circuit or in district court decisions of the TTAB. And back then, I was kind of a half trademark, half patent person. So I also defended decisions of the BPAI in district court and at the Federal Circuit. And we also had a really fun part of our job was to work with the United States Solicitor General's office on any intellectual property cases that were at the Supreme Court. So since the USPTO director is an IP advisor to the president, then kind of in that capacity, they would reach out to our solicitor's office and we would work with them on briefing the cases on behalf of the government and preparing folks from the Solicitor General's office for those arguments. So it was exciting and enjoyable. And then prior to that, I spent a few years at the U.S. International Trade Commission working on unfair import investigations that were IP-based, and then a few years in private practice at the very start of my legal career.
So obviously, seriously credentialed, so I spent time as a solicitor and at the ITC, so she obviously knows what's going on at the TTAB. So next up, Judge Stacy White.
All right, good afternoon, everybody. It's good to see so many familiar faces and some new ones in here too. I'm Stacy White. I'm a lead judge with the Patent Trial and Appeal Board. I've been with the USPTO 11 years now. For those of you that knew me in private practice, 11 years, y'all. See, I have an undergraduate degree in computer science, a master's degree in human-computer interaction, and a law degree from University of Illinois, so I'm not a local. I came down to the DFW area because I got a clerkship with Judge Barbara Lynn here in the Northern District, and I stayed. I was planning on going back to Chicago, but life did not take that turn. I worked at the law firms of Jones Day and Alston and Bird before joining the PTO. And in the 11 years I've been at the PTO, I've been, like I said, a standard judge and now a lead judge. So I supervise other judges in addition to my duties overseeing mostly AIA trials, but still a few ex parte appeals.
Thanks, Judge White. And this last person, Officer Neerberg will not allow me to call him judge. So, Officer Neerberg.
Great. Thank you for having me. Again, I'm Brad Newberg. I'm one of the 3 inaugural copyright claims officers of the Copyright Claims Board. And I don't mind if you call me judge. I just won't call myself it. We can't get into trouble. So I also am, I'm from, not from around here. I went to both undergrad business and law at University of Pennsylvania, clerked at the Southern District of New York, which is where I fell in love with intellectual property. We had a bunch of copyright and trademark claims, one more insane than the other, and I said, that's for me. So I became a copyright and trademark litigator right after. Spent out 25 years doing that, was lead counsel on over 100 copyright litigations, over 100 trademark litigations. Michael said we're supposed to pump ourselves up, so I was National Law Journal named me as an intellectual property trailblazer in 2017, and then in 2021 I got approached to say by a couple of people say, hey, have you thought about getting rid of the billable hour and putting your hat in the ring for one of the copyright claims officers? I did, and I was appointed in 2021, and yeah, we'll talk more about it, but part of the job was literally building it from scratch, hiring staff, drafting hundreds of pages of regulations, and we launched in June 2022.
Well, thank you, Officer Neerberg. As you see, we have some experts up here who can answer just about any question you have, but we will go through a few things here in the interim between your questions, right? So starting with you, Judge White, what are your responsibilities at the PTAB?
Okay, I do mostly AIA trials, so I preside over contested trials, mostly in the electrical and computer science area. I still do dabble in a few other things, but I would say electrical and computer science area is home for me. I do some ex parte appeals, and those are appeals from people who have been trying to get a patent and have been unsuccessful in front of the patent examiner. So I preside over some of those. As you know, we work in panels of 3. And on the AIA side, at least we have strict statutory deadlines, so we have to get things out in a quick, fast, and a hurry manner. So that's the majority of what I do. In addition, I do some administrative things for the board itself, and I oversee our PTAB pro bono program is one of the things I do, but talk about that a little bit more later.
Okay, Officer Neerberg, you mentioned some of the things that you're doing to get the CCB started up, but what are some of your other responsibilities?
So it's really overseeing the staff with the other 2 officers, sort of making sure all the trains run on time. We are basically in between a federal court and a small claims court. So think of all the extremes of the federal court and all of the, landlord tenant people come in, just say what their dispute is, and you have to solve it. So we're in between. We have a process where claims come in and we have to decide whether they're what's called compliant or not, whether they can go forward to the next step, because sometimes we get claims that need a lot of work or just aren't acceptable or we don't have jurisdiction over. And then we have conferences, oversee discovery, and then decide the case at the end.
Okay, thanks. Judge Lynch, same question.
Okay, well, our Trademark Trial and Appeal Board, for those of you who are not familiar with it, we are deciding issues of trademark registrability. So we have ex parte appeals where a trademark examining attorney has finally refused registration and an applicant wants to appeal. The first level of a review is with us at the agency. And then we also handle inter partes cases. oppositions where a third party wants to step forward and object to a mark registering or wants to challenge an existing registration in a cancellation proceeding. Unlike the PTAB, where some of the judges specialize in one type of proceeding or the other, we do, all of the TTAB judges do all types of proceedings, and like the PTAB, we sit in 3-judge panels.
Okay, so Officer Neerberg, since you're the baby of the bunch with respect to the establishment of the CCB, can you just talk a little bit about why you were established and how that came to be?
Sure. And I actually talk about us in many different ways as the toddler. And since I do, today's our 20-month anniversary. So we're still speaking in months, not years. So the CASE Act, which is the act that established the Copyright Claims Board, was signed at the very end of 2020. And the goal is to make things better for a wide range of people. What you had, the main problem it was trying to solve is, as everybody here knows, all litigation is expensive. And copyright litigation is also very expensive, maybe not patents, but it's still pretty expensive. And you have a lot of copyright cases where the value of the claim is dwarfed by the actual expenses of litigation. And what you had is both sides being upset by that. You have content creators who feel, well, I have no recourse to enforce my rights. You have on the other side, people who do get sued in federal court who think, well, I have to settle this. I have to pay an outrageous sum because even if I win, I will have now paid an even more outrageous sum in legal fees. So the whole thing here is to streamline things, make it time efficient, cost efficient for these specific copyright disputes. And we handle only copyright infringement, declarations of non-infringement. So if somebody's threatening you with an infringement suit, or claims involving misrepresentations in a DMCA takedown or counter notice.
Judge Lynch, the TTAB has been around since what, the late 50s?
1958.
1958. So I'm sure there are folks in here who are familiar with the what and why in the background of the TTAB, but what's your elevator speech with respect to that?
Well, the 3 types of proceedings that I already mentioned, and similar to what Officer Newberg said when our board was created by statute in 1958, the stated mission was to streamline administrative proceedings of the type that I mentioned before. So I think we have only, we're a fraction of the size of the PTAB, about less than a tenth of the size. So there are just about 25 of us judges, and then a chief judge and a deputy chief. And we are continuously looking at how to streamline proceedings at our board and make them as user-friendly as we can, including kind of revamping our rules every 5 to 8 years. And since, as I mentioned from my former job, I'm kind of a rules nerd, I've been involved in that process a few times as a part of the TTAB. And so that's something that I like about it, that I've enjoyed about it, is that I think the board is constantly trying to learn from prior experience and trying to listen to our users and stakeholders about what, might be more efficient. And we'll talk, I think, later in the panel about some of those measures that we've put into place.
Judge White.
Well, all right. Depending on how you want to define us, we are either as old as this country or 12 years old. There's been some version other of the PTAB going back to the founding fathers. And what we were initially instituted to be was a group of people that would look over what was going on with the examinations and say, yes, this is working right, or no, it's not. And that is still our core functionality. We do a lot more ex parte appeals work than anything else. But that's really just a function of giving a second set of eyes to the examination process and making sure that the rejections that are being issued are in accordance with law and supported by evidence. The other bucket of things we've been doing ever since the American Invents Act is our contested trials. And those are opportunities for you to be in a different type of forum to raise questions of patentability. Should this patent have ever been issued in the first place? And have a chance to argue these questions to a group of so-called expert judges. We all have technical backgrounds and we all have legal backgrounds. One of the examples I like to use is one of the early cases I had had to do with source code, and we were looking at a computer science issue, and we started going through source code and going through and saying, well, if you define this way, and the lawyer was like, I've never had to go through source code like this with a judge, because most federal judges are generalists, and I got a degree in computer science. I'm not going to be freaked out by defining some variables. So it's a different type of experience, I'd say, arguing in front of us than what you would get in a district court. And it's supposed to be a quicker and cheaper way of doing things. Is it as cheap as some people would have liked? Probably not, but it's still not as expensive as district court gets.
So that leads us to the next logical question, and that is, how does adjudication before the PTAB differ from that in the district court?
Well, I like to tell people that you start off our contested proceedings, the AI proceedings, with basically what would be like a summary judgment motion in district court. You have to come to us with your evidence, your arguments, and know exactly why you think this patent is no good. And that petition right there, we look at it and see whether you've got the information. Do you have the goods here to even take the time to go forward with that? In a district court proceeding, you're going to take a little bit more time to ramp up to that point in what's going on, because like I said, our petitions are very similar to what you would see evidence-wise at a summary judgment sort of level in a district court. Our proceedings are very streamlined compared to district court when it comes to discovery. You just can't get as much stuff in front of us. We cannot go as broad as far as the different bases for looking at unpatentability. We are pretty much cabined into 102 and 103 in most circumstances, unless you go into our PGRs, which have a few other things available to them. And you are limited as to the types of evidence in some senses. So it's a more limited procedure than what you can get in district court. And of course, we don't have juries. You are arguing in front of a panel of 3 judges, which is a different experience, and it changes the way you would approach something and how you would argue it, because it's a different audience for your arguments.
Well, you have limited discovery, you're trained, you're a little more efficient than, say, a district court, but there's this issue of claim construction. How does that differ, or how is it the same as a district court and what you guys do?
A lot of it is the same now. When I first joined the board, all of our proceedings were under what they call the broadest reasonable interpretation standard, which is a different claim construction standard than what was used in district courts. In the last few years, around, I think it was 2018, but don't judge my memory if I'm off a year or two. We switched so that the AIA proceedings were also under the same standard as was being used in the district courts. Now, our ex parte proceedings, which are more of an extension of what's going on in the examination process, those are still using the broadest reasonable interpretation standard. But in front of us for a contested trial on an issued patent, we're using the same standard, the same case law that you would use in a district court for your claim construction proceeding. It just happens a little bit quicker because we're on a different clock and we have less time to go back and forth on things.
Okay, well, thanks. Judge Lynch. How does a proceeding before the TTAB differ from that in the district court?
Sure. Although we do have some similarities in the sense that a lot of the substantive law is the same, and we do generally apply the federal rules of civil procedure and the federal rules of evidence at the TTAB. I would say the big difference is that we are compiling a written record. So the parties, although they can submit witness testimony, the testimony comes in as an affidavit or a declaration or a deposition testimony. We're never having live testimony taken, in person in front of the judges who are going to decide the case. So we just have a procedure where the parties submit their evidentiary record online. including that written testimony or whatever documents they want considered. And then in many of our cases, there is no oral hearing of any kind. And so the case will just be after the parties go through discovery and have their trial time where they're submitting that evidence and creating the written record by submitting the evidence online, then the case will be ready for decision by the judges. And we just go and review the record and the briefs that the parties have filed and then decide the case. There is an option to have an oral hearing. And when we have those, they're really more like an appellate type argument. The record is already closed. And so it's an opportunity for the judges to ask questions and follow up on material in the briefs, but, very different from having a live trial. And as Judge White was mentioning, where it's a different experience than appearing before a generalist judge or a jury if you're in court. We, eat, sleep, breathe trademark law. So you're going to be before judges who are very familiar with the area of law that we're working in. And so you're able to tailor your case accordingly.
So you're a little bit less formal, but what about the expense associated with the TTAB?
I think in general, we're thought of as a less expensive forum than in the courts. And we also, part of the flexibility, I think, at the board is that we generally are very receptive to suspending the proceedings to allow the parties time to try to negotiate the settlement, a settlement, and the vast majority of our inter-parties cases in fact, do settle. I think a lot of times we are more flexible about that than some of the courts that are stricter about their dockets. And so that's another reason that sometimes parties might prefer to handle some of their trademark matters before the TTAB.
Okay, now, Officer Neerberg.
Sure. The answer to that question for us is a lot. So I'll give you the quick hits and around to answer questions such. But first is damages. And everything I'm going to say goes to the sort of the streamlined nature of things. So our maximum damages for any CCB proceeding is $30,000. Our maximum statutory damages for any particular work infringed, if you choose statutory damages, is either $7,500 or $15,000, depending on when you registered your work. The CCB is voluntary, meaning a claimant can choose to go to federal court or to us. And then if the claimant chooses to go to us and it's a compliant claimant that gets served, the respondent, so we have officer, not judge, claimant, respondent, not plaintiff dependent. The respondent has 60 days to opt out, to say, you know what, no, I'd rather you take me to federal court. If they don't opt out, that's when we start an active proceeding. Talked about the streamline and being cost efficient. Everything with us is virtual. So you never have to travel to Washington, D.C. to have your case heard. Motion practice is fairly limited. You can have your own attorney, but we set it up so that people can be pro se. About 3/4 of all of our parties and participants are pro se and represent themselves. That goes for businesses as well. A business can represent themselves before the CCB, even a corporation. We don't have depositions. We don't have third-party subpoenas. You can bring someone in voluntarily as your witness, but we can't subpoena them. And we have, and this goes to some of the expertise Judges White and Lynch were saying, we've drafted the interrogatories and document requests for you. So you don't have to spend a lot of time drafting your own, nor can you object to them. And so you can ask for extra discovery, but it has to be very narrowly tailored, and it really cuts down on disputes and again gets to that time limited thing. And we have a brand new electronic filing system that we developed that's intended to be way more user-friendly than, say, Pacer, so that it actually, for a claim, walks claimants through questions so that they can really fill it out pretty easily. And going to the expertise, since 3/4 of our participants are pro se, our goal is really, look, we have decades and decades of experience between the three officers. We need the facts. We need the facts really presented in a clear way. People are allowed to cite law to us, of course. But if it's an attorney against a pro se person, we don't want there to be a massive disadvantage. So we really rely on just getting the facts out. And finally, I'll just say we also have this compliance process, which makes it differently, where we look at the case as soon as it comes in to see if it's a case we can hear, to see if it's clear enough that we understand it, that the respondent's going to understand it, and sort of a three-strike system. If you can't get through that, your case is dismissed without prejudice, but if you can, then you're given the compliance order and it says, okay, go ahead and now serve the respondent. So those are sort of the quick hits for you.
So I'm curious, how many folks do we have attending today that are trial attorneys? Just raise your hand. Patent, trademark, copyright, doesn't matter. Okay. How about folks who have been before the PTAB or the TTAB? Okay, about the same number, about half. So I think the trial lawyers will tell you that anytime that they're faced with someone who files a pro se complaint, it can be a little difficult. So, given that you're trying to streamline this copyright infringement process through the CCAB or CCAB, everything's got an A in it except for you, and you're not a judge, you're
Right.
an officer. I mean, you're making my life difficult over here.
That's my job.
So, how do you handle that pro se complaint so that you don't make it difficult on these guys that are like, oh my God, I got to deal with another pro se complaint?
You know, there's a little more, there was a lot more hand-holding involved. So, right, so the compliance process, I mean, we do get wild claims and those don't get any further than us. They end up getting dismissed. In fact, we've had about 750 claims in our 20 months that have been filed with us. Just about half of them, just under half of them, get dismissed at the early stage. So when you have something served that gets before us, it's a little bit more coherent, a little bit more concrete. Everybody knows what's going on there. And then it's a matter of, in conferences, being much more explanatory, having a little bit more patience, telling people, you know, look, I've had people where you might be familiar with like a Rule 16 conference where, you know, it's just like, hi, I'm Brad Newberg. I'm here for the plaintiff. And I will ask people to introduce themselves to the record and they'll say, you know, hi, I'm Jim Jones and I became an artist in the 2nd grade. And they want to tell me, and I've got to, you know, sort of corral all of that. So there's a little bit more of that hand holding and sometimes we'll have to issue orders. And what we do when we issue orders, even scheduling orders, there's instructional stuff that comes with it. And we also have a handbook that's online that goes through chapter by chapter all the aspects of a CCB case, which is actually really helpful for the attorneys as well, because let me tell you, a lot of the attorneys have the same issues you're talking about that we see. So there is more handholding, but we haven't found that process to be frustrating when we have a pro se on one side and attorney on the other side. And actually, we found that the attorneys seem to enjoy that it's a little bit less formal as well. And in fact, just a quick thing, we've actually experienced way fewer opt-outs than we thought we would, because people said, oh, large corporations, they'll all opt out. They'll want to go to federal court. And we found that as much as you can love being sued, the corporations love being sued at CCB because they know the damages are limited. And what they often do is they'll have in-house counsel who never gets to try a case come in and be the attorney, or they'll go to their firm and say, can you handle this? And the firm will say, I've got a junior associate who would be great. He needs great training on copyright matters. So, you know, we get all of that.
First of all, I'm happy that the Jim Jones in your example there was an artist.
Yeah.
Those in the
All right, I
audience
had
who
to
are-
come up with a name on the spot, so, you know. Sally Smith.
Okay, you might want to put that one in your back pocket. I know there's some law students in here going, what? Why is that so funny?
Fair enough.
Is there a standard that you use for dismissal once the complaint is filed, or is it just this
There-
review?
So there is, there's a standard on two things. One, is it the type of claim we can hear? So sometimes people will file a patent or trademark thing and say, you know, and we'll have to be like, well, that's not us. I mean, that's a small amount. But for instance, we can't hear claims against foreign respondents. So you can't sue just because you think someone's infringing you in China or France or Brazil, what have you, you can't sue before the CCB. And sometimes people do. And those are what we sort of internally term as a fatal claim, because there's nothing you can do about it. You can't all of a sudden make them United States resident. But then they'll have other issues where it's, hey, maybe there's something here, but we can't understand it. They haven't really pled the ideas of, what's substantially similar here. Throw out copyright terms like access, substantial similarity, but what's the story? We don't quite get it. Or, hey, the stuff that you're claiming is similar here is just an idea which is not protectable by copyright. And we give a detailed compliance order that says, to be compliant, you're going to have to allege, more than this. And we try to give some examples, specificity, so that they can fix it. And, about 60% of people either get through the first time or are able to fix it on an amended claim. And about 40% don't.
Okay, so I neglected Officer Neerberg when I asked my question. How many of you all have filed an action or responded to one before the CCB? Okay.
Yeah,
so-
I would have been surprised.
Yeah, so you see, I'm not neglecting Judge Lynch or Judge White. I'm just as intrigued with this CCB thing as you all are. And a lot of you guys have been before the PTAB and the TTAB. So another question for you, Officer Neerberg, and that is, how often can someone come before the CCB in bringing claims or the same type of claim?
Yeah, so we do have a limit, a yearly limit. So we have a limit on both claimants, which I believe is 30 claims maximum. We've really only had one claimant even really come very close to that. And in fact, there were a lot of proclamations made about the CCB beforehand. Oh, it's all going to be what are termed copyright trolls and those attorneys. We haven't seen any of that, or it's going to be the same few people just using it over and over again. And of our 750 claims, certainly at least 550 different claimants that we've had. We get a lot of different sort of claimants on that, but we have this 30 claim per year claimant. We also actually have firms, because there was that worry of the person who makes it the cottage industry, where we have a attorney and firm limitation, but we haven't seen anything close to that. And I believe, by the way, just to put in a plug, we do have a bunch of pro bono sort of people that sign up with CCB, including lots of law school clinics. And it's much looser for the law school clinics.
So if someone files a claim before the CCB and the response contains a counterclaim
Yes.
that's unrelated to a copyright claim, but between the same parties based on similar facts, what happens to that?
Yeah. If it's something totally different, that isn't copyright based, we can't hear it. The only exception to that is we can hear certain limited contractual counterclaims that are very related to and affect the copyright infringement claim. But otherwise, what we have to tell the counterclaimant is, we have instructions. Look, if you want everything federal court, you might just want to opt out. But otherwise, you handle your claim here. And if you have a counterclaim, you might have to bring that separately in another venue.
Okay.
So a lot of times what people think is, it's not worth it. I'll just handle the copyright stuff here and we'll see what happens.
So you handle infringement matters, but do you also handle DCMA claims as well?
Yeah, we handle DCMA for both misrepresentation in a takedown notice as well as a counter notice. So we'll get misrepresentation claims that say, well, this person's not only infringing, but they filed a counter notice saying they weren't infringing. That was false and material. Or we'll get the flip. We'll get the, hey, this person said I was infringing because they're just a competitor of mine and they just wanted to take down my stuff. And so I'm suing for misrepresentation and a takedown notice.
Okay, so I'm going to give you a chance to solicit some more officers. What are you looking for as you go across the country and do your show and tell everybody what's happening as far as officers are concerned within the CCB?
What are we looking for in terms of people potentially filing? I mean, the biggest thing is to really consider it. If you are a practitioner, for instance, and you get, it's awareness. Right now, we are, as you can see, nobody's been before us that's here. We are very low on consumer awareness, let's just say. We wouldn't, as dilution goes, we certainly wouldn't be famous. To throw that out there. So we are looking for people to really consider it for their clients. And even if you get a call, and somebody says, oh, I have this claim, and you think it's a valid claim, but you're like, look, it's too low for me to handle it on contingency. And you'll spend too much if you just hire me. And your instinct might be like, I can't help you. At least the knowledge will be now you can say, hey, have you considered the Copyright Claims Board? And then you can either, push them towards that, or you can even just say, look, I'll take a look at your claim for you. You can hire me for just that. I won't represent you. If you can, great. But, the awareness is great. And on the flip side, if you get approached by a client that says, I just got sued at the CCB, the answer, I can't say in every situation. If you might feel you need a ton of discovery and things like that, you'd say, oh, maybe opt out. But the answer for most cases is probably going to be to your client, hey, this is a good thing. You're maxed out on your potential damages. You're not going to have to go through a lot. So for us, it's getting people out like yourselves to just understand what the CCB is about and why it's good for clients.
Do you need a copyright registration in order to file a claim before the CCB?
You do not need a copyright registration. You need at least, so unlike federal court, which when the Supreme Court decided that you had to have registration before you actually filed your complaint, the Case Act allows it that you must have either a registration or a copyright application, but it must be in before you file the claim. Otherwise, that becomes another sort of fatal claim. Even if it's the next day, the answer will be, well, fine, you're getting dismissed and you can refile, but we cannot hear a claim unless the application was in before the claim.
Okay. Judge Lynch, we've heard about the pro se folks before the CCB. I know you deal with a lot of pro se folks within the TTAB. How do you all handle that situation?
We do. We still have a fair number of pro se parties, and actually a lot of I won't call it a burden, but dealing with the pro se parties falls on our interlocutory attorneys. So in addition to the around 25 judges I mentioned, we have around 20 interlocutory attorneys. And for us at our board, they function a lot like a magistrate judge functions in federal court. So they handle all of our motions work leading up to the point where the case is ready for a final decision. They oversee discovery. And so I know one of the approaches they often take when they have one or both pro se parties is that whereas usually the parties are left to themselves to have a discovery conference at the outset of the inter parties case, if there is a pro se, then the interlocutory attorney is much more likely to indicate that there'll be board participation in that conference and that the interlocutory attorney will be a part of it. So they can get everybody together on the phone, answer questions, talk through how the proceeding is going to go, and try to help make sure that it's on the right track. And then that interlocutory attorney involvement, may be a little heavier as the case moves forward, just to make sure that the pro se stays on track and that the case stays on a good track. So the judges, I would say, are probably a little spoiled because the cases come to us, not until they're fully briefed and ready for a final decision. So we may have, it may be a little more unusual if we have a briefing, for example, from a pro se party rather than when we have attorneys involved. But other than that, I think most of it falls to the interlocutory attorneys at the board to help with.
Okay, so Judge White mentioned a few minutes ago the AIA and how that sort of changed what they're doing with respect to claim interpretation and, first to invent versus first to file. So you've had the Trademark Modernization Act.
Right, TMA.
Yes, TMA.
Uh-huh.
Too much to say. How has that impacted your practice?
It is really just starting to impact the TTAB because we now, as you may know, a part of the idea behind the new TMA proceedings was to offer an even more streamlined, potentially faster and cheaper way of moving an unused registered mark off the register. Those are handled over in the examining operation in the first instance. And part of the idea is that if you perhaps see a mark on the register that you think is unused, maybe it's standing in the way for one of your clients who wants to clear, using a new mark, then you might use one of these proceedings, and it lets you, similar to what Judge White was talking about, you put forward your prima facie case that you've done an investigation and the mark appears not to be in use or wasn't in use as of the relevant date in a use-based registration. And then you get to kind of wash your hands of it and walk away. And then assuming the attorney in the examining operation who's handling it agrees with you that a prima facie case has been made, then they're going to be the ones who then go out and call upon the registration owner to come back and rebut that prima facie case and prove that they are still using the mark or they're still using it on all the goods or services that have been challenged. So those went into effect really just in late 2021, and we've only reached the point where the first two appeals of those decisions by the attorneys in the examining operation, appeals of those can come to the TTAB, and that is a new type of proceeding for us. So there'll be ex parte appeals instead of involving applications. These will involve registrations. And so I think we have our first two that are almost ready for decision. So I think that the impact hasn't really hit us fully yet, and we're going to see what comes. It has been very interesting to keep an eye on how those proceedings look over in the examining operation. They seem to be, they're getting more and more used as time goes on. And I think in some ways, some of the types of non-use claims have been unsurprising, and they're what were anticipated when the TMA was put into place. And then other times they have been not what we expected necessarily. So there are a fair number where there are situations where we know that when you're applying and registering a mark, it's really important to identify your goods or services accurately. Quite a few of the challenges I've seen in the TMA proceedings are perhaps where the mark is in use, but it doesn't align with the way the goods or services were identified. Perhaps they really weren't described very accurately. And so that can present an issue that wasn't really what the vision was for the proceedings at the outset. So we may be dealing with some different kinds of issues than what we thought.
So it sounds like the TMA may have brought in an issue as it relates to fraudulent evidence before you all trying to prove up use. Is that something that you've been having to deal with?
That was certainly, we did a pilot program at the agency in advance of the TMA. And one of the reasons that I think, or one of the reasons behind the legislation was us finding out through this pilot that in over half of the instances where use-based registrations were being maintained and we were getting sworn statements that the mark was still in use on all the goods and services listed in the registration, when we did a pilot program where we randomly audited these maintenance filings, we found that in more than half of the cases, the registration owners were not able to come forward with proof of use in connection with all of those goods and services that they had sworn they were still using the mark on. And so the TMA proceedings were in part put in place out of concern for the integrity of the trademark register. We want it to be a reliable reflection of what is in use in commerce. And so I think even probably since that time when the pilot was run, we've had an enormous uptick in trademark related fraud before the USPTO. And there are a lot of different aspects to the fraud. but a lot of it are cases where registrations are obtained and it's now coming to light that the specimens were manufactured, that they're just digitally created. I like to tell the story of one of our favorite ones was where the applicant went online and found a photograph of one of those Times Square digital billboards, took off, Samsung or whatever was on it, put their mark on it, and submitted that as their specimen of use. And so as those things, are coming to light, then we're really wanting ways either for third parties to come forward and let the agency know about it and challenge those registrations that were obtained fraudulently. And one other component of those TMA proceedings is that they also can be director initiated. So sometimes even where we're not getting a formal petition under the TMA, when we're finding out about situations like that, then the director is able to initiate her own TMA proceeding and then potentially use that to move some of these registrations off the register.
So, and what you typically do is just, your remedies are cancellation.
Right. Yes. As I mentioned, we're kind of a board of a pretty limited jurisdiction, just deciding registrability issues. So there are no money damages. There are no injunctions.
Okay, so Officer Neerberg, you go to the CCB, you get a judgment. I'm assuming you call it a judgment.
Yep.
What do you do with that?
So that's a good question. I mean, I don't know the answer, but it's a good question for practitioners. So because of the way, and you've heard I'm called officer, not judge, because of the way we were set up, what we issue is an opinion and it is enforceable, but it's enforceable in federal court. So it's one of the reasons why we really like when both parties are there, because when both parties are there participating, there's a much higher level of settlements. And even when it's found against one party, they tend to pay because they participate in the process. The problem would be if someone didn't pay, or in our default cases. And in our default cases, we are getting a default judgment and we're saying, okay, if the claimant wins, sometimes claimant doesn't win even if there's a default, but if the claimant wins and there's X amount of damages, they can then go try to find the respondent and say, I won this, but otherwise they go to federal court. Now, the federal court is supposed to be a quick rubber stamping process where the federal court simply enforces it and actually gives back, you get it added to it, the costs it took you to get to federal court. So if you have to have a filing fee or anything like that. But it is an issue with the sort of steps that they need to take to make us not like a federal court. That can be an issue for parties.
Okay.
We haven't had too many things come up where it's been a real problem yet. But I imagine at some point somebody's going to be an angry customer and say, hey, I thought I was avoiding federal court to begin with. Which is why we always try to give our instructions very early and give the handbook and such, so we can avoid surprises like that.
So Judge White, one of the things that you mentioned earlier was the efficiency of the PTAB. And some of us who've been around for a while know that the predecessor to the PTAB was a little slow, to say the least. So how have you all increased the efficiency within the PTAB?
Well, we ramped up hiring around the time of the American Vince Act. We went from being a board of about 50 or 60 judges to nowadays we're up at around 220. I think at our height, we were like 265. And that has allowed us to get a lot of work done. When I first started with the board, our ex parte appeals, I was picking up cases that were 5, 6, 7 years old. And nowadays you can get an ex parte appeal through the office in a year. And that, I think, has really changed the game for people that are considering whether to go the appeals route or to do an RCE or something else, is the fact that they know that they can get through our process in a much quicker turnaround time. So that I think that's one of the big changes as far as efficiency. On the AIA side, we are statutorily efficient. We don't have the option of really letting these processes hang around for too long. It's a 1-year statutory deadline. So 1 year from the time we institute, we have to have a decision out. And unless there's, a rare circumstance going on, that's what happens. So our processes move pretty quickly, and there's not a lot of time in there to be lollygagging around. So we push things. You have to get your discovery done in a short period of time. You have to get your briefing done in a short period of time, and you got to have your hearing at a specified period of time. So it moves. It definitely moves pretty quickly in front of us.
So what's the weight between the ex parte work that you're doing versus the AIA,
Like the numbers of cases that we go through,
if you can recall?
I think we get around 10,000 ex parte appeals out in the course of a year. So we're doing high volume on the ex parte appeal side. On the AIA side, it's not quite that volume. I don't know the exact number. We usually get around about 100 to 100 and I'd say a busy month, 150 cases filed in a particular month. And then on the output side of that, it's a smaller number because of course, along the way, a lot of those cases do settle.
So are there any jurisdictional boundaries or geographical boundaries as it relates to the internal operations of the judges within the PCAS?
We are decidedly non-geographic. When you get a case at the PTAB, your judges could be from pretty much anywhere in the country. We did not want to get into a place where we would be developing like circuit splits within the board or something like that. So it's a docketing process where you could end up with 3 judges in Alexandria, 3 judges in Dallas, or you could have 1 judge in Dallas, 1 judge in Denver, 1 judge in Detroit. It really doesn't matter to us. It's more on the subject matter side than anything geographic.
Okay, so if Wei files a case and she wants it to be in front of you, then that's probably not gonna happen. So she could go somewhere else.
It's a grab bag. She could end up with me.
Judge Lynch, you guys are doing cancellations, oppositions. What do your statistics look like over the last, say, 5 years?
Well, on average, I think last year, for example, in terms of final decisions that we issued, it was around 600. So about 400 of those were ex parte appeals, and then about 200 were those inter partes oppositions and cancellations that I mentioned. The filing levels on an annual basis are much, much higher than that. So last year, our appeals were 3,655. Oppositions were 6,300. Cancellations were 2,300. So as you can tell from the disparity between the numbers of cases that are filed and the number of decisions that issue a year, both for our appeals and our inter partes cases, the vast majority of them, the appeals are withdrawn or the inter partes cases settle before they reach the point of final decision.
Okay, now, as far as the future goes, so Judge White, we have a lot of young lawyers out here who would probably like to have some experience before your board, but they're working with people who have been there for a while and the client feels comfortable with them. How do you guys handle that situation?
Well, we encourage the Mr. McGee's of this world to invite their less experienced colleagues out to argue in front of us. We have joked many times about the Post-it note army that we see behind you, passing you notes to let you know what's in the brief that a lot of them drafted in large part. These people are more than welcome to get up in front of us, and we have something known as LEAP, the Legal Experience Advancement Program, where you get an extra 15 minutes tacked onto your argument time if you allow one of your more junior associates to be part of the argument. And I can tell you from my personal experience, people have done phenomenal work. They have done jobs that you would be overwhelmingly proud of if you let them get up there, because they realize that it's hard to get that stand-up experience in front of a judge, especially your first 1 or 2 times out there. So when they get that shot, they get ready for it and they come in front of us prepared and ready to go. So we've seen them do wonderful work. We do have sort of what we call the little safety valve. If somebody gets up there and has some problems, you can jump up there and help them out and get them to where you needed it to go during the argument. But honestly, people haven't needed it. These younger associates have done great work and they have really argued things to the credit of their clients. So please consider having them come on out there because it's good for the profession. We can't really have a pipeline of attorneys that are ready to step up and be in front of that podium if we keep letting the same people argue every time. We've got to open the doors of opportunity so that more people get that experience and are ready to be in that first chair position. So give them that shot, and I think you will be very proud of what you see.
I have not been before Judge White ever, I think. So that was just a throwaway comment.
That is a general statement.
Not that I was standing before her with folks handing me Post-it notes, so I would know what to say.
But you know what I'm talking
I-
about.
I just felt like I needed to clear the air on that one. But, Judge Lynch, how do you incorporate technology into the TTAB? I know everything is remote, but is there any particular thing you can point out or say, hey, this is better than this, or we like this?
Technology wise, I mean, we are 100% electronic filing, and have been for a while. We are in the process we're working on new and updated, filing systems. So be on the lookout. I think we do have some beta testing going on with a few, outside users, to get input on it. So please be on the lookout if you see opportunities for that. That's something really like our information technology drives a lot of what we do at the agency. So it's really important for us to hear from you all when there are opportunities to give input when we're developing new systems, or even honestly, if it's complaints about our existing systems and you have pet peeves, it really helps us to hear about them. So just a little plug on that. In terms of how technology works at the board, we also do all of our work electronically, and we're looking at the written record in our TTAB Viewed as the name of our database. So I think it's probably not so much a technology comment, but I will mention, because I hear from a lot of my judge colleagues about this, it's very, very helpful to us that you follow our request to cite to the record using our TTAB View database sites instead of picking your own citation system where you name all of your declarations by the name of the declarant, or you give us your Bates number pages, because we often have very large record cases, especially in the trial proceedings. And so keeping in mind that all of our work is done electronically, it really helps us if you cite to our database in the record to help us move our cases most efficiently.
So Judge White, I've often heard that when you file a brief, you should look at it on your iPad to make sure that it's readable and that your figures can be seen and you don't skip pages. Is that a good rule of thumb to follow or not?
That's probably a good rule. I mean, looking at things in different ways to make sure that nothing has messed up in the filing process is good for you and me. I mean, you want to make sure that you are representing your client the way you intended to represent your client. And it's a little easier for us when things are OCR'd and working right. So use the technology the way it is intended and use it to make life a little easier rather than a little harder. So yeah, that's a good tip.
So Officer Nearbird, what are some tips that you would like to leave these folks with as it relates to the CCB?
So what we find even with attorneys is, so some tips. One, we really do, I know it seems basic, but actually read the orders, read the instructions, and get things in on time. I mean, it's amazing how many times we even have to say to attorneys, hey, this was due yesterday. And like, we give more chances than a court will. But we ask people read the orders, read the instructions. We really try to tell people what to do. For performing in front of us, making sure the copyright registration applications in order, that you're suing on the actual registration that you say you are. Remember, we have access to all the Copyright Office records, so we can see pretty quickly if you haven't. Also, we have had one of the biggest issues we've had with attorneys is on damages, and thinking, because in courts, people often threaten the 150,000 statutory damages. And so they think, oh, that's gonna fly. Like, I just want the maximum statutory damages. I don't have to show anything. And truth be told, is even if federal courts doing their job right, statutory damages are supposed to have some relationship. If you have had no harm whatsoever, and if the other side really hasn't gained anything from it, you're not supposed to get at the upper echelon of the statutory damages range. And we have had attorneys come in who just say, well, why aren't you giving me the most? I've shown infringement. And well, you haven't shown that you were harmed in any way. And so that's the biggest issue we see with attorneys. They'll prove their infringement, and then they'll be upset that their damages are low. And frankly, I think this goes for everybody, but treat staff with respect. I don't actually get too peeved if an attorney says something to me, but if I find that they sent an email to my staff treating them as if they're the hired help, that's not pleasing. Also, you mentioned with the future, I will say to the students and young attorneys in the audience who are going to potentially like firms and stuff, nothing creates value for your partners and other stuff to actually have knowledge that they don't. And as you saw from the lack of raising of hands for Copyright Claims Board, actually knowing about this and potentially through a clinic or through other stuff, being before us, could present real value for the people you work with in the future.
Thank you. Thank you. And just to piggyback on Judge White's pointing me out for not using associates, I will say that as a law firm partner several years, yes, someone who comes with knowledge I do not have, which is not that difficult, would be great. So Judge Lynch, the future, the TTAB, and some pointers for these folks to take with them as they leave.
Okay. I guess one pretty new initiative we have going on is a pretrial conference pilot. So part of the streamline aspect of most of our cases is that we can, in the best case scenario, that interlocutory attorney I mentioned earlier will set a schedule, and then the case will kind of proceed along without a lot of further involvement by anybody from the board until it's all done and the briefs are filed and it's ready for decision. But we have found that unfortunately not every case is like that. And so we have cases where at the end of the day, the judges end up with some very large unfocused records. Or we have a lot of unnecessary motion practice. And so we're running a pilot where if we're spotting those kinds of cases earlier in the process, then we are putting them in this program where they will have a judge and an interlocutory attorney assigned to do an orientation conference. And then we're doing something like those pretrial conferences and final pretrial orders that you might be familiar with from district court trial work, where we're trying to put a cap on, eliminating some of that unnecessary motion practice and ending up both for the parties and for us with better, more focused, more relevant, and hopefully smaller records at the end of the day. So it's absolutely not for every case. In fact, I think the pilot's been in place for some months now, and we've only so far identified 6 cases that are in it. So it's a small number. Not to worry that we're placing that it'll be an additional burden in some ways to, participate in this process and do this order. So not all cases, but the select few, we're trying to make the process a little cleaner and more streamlined. In terms of case tips or practice tips, one, I always like to put in a plug for what we call accelerated case resolution. And we have a web page about that, and we have information about it in our TBMP, our board manual of procedure, but it's an opportunity in inter partes cases. The most common model is what we call the summary judgment model. We have lots of inter partes cases where, one or both parties move for summary judgment. And, they're putting all that evidence in the record, briefing it, presenting it to us on summary judgment. And most of those summary judgment motions are denied because the board identifies genuine disputes of material fact. But maybe there's really no further development of the evidentiary record that needs to occur. And so in those instances, we would really encourage this ACR model where the parties agree that even though it might not be appropriate on summary judgment, they will agree that the board can go ahead and resolve any disputes of material fact. So then instead of having that two-part process where the evidence is submitted twice and two sets of briefs are done, if summary judgment isn't appropriate at that stage and there's, no more the parties need to do, then they'll just say, you can rely on these summary judgment briefs as our final briefs, and you can rely on the summary judgment record as our evidentiary record in the case and go ahead and decide it. So it is not used as often as we think it should be, but I would like to, highlight it for practitioners and encourage them to think about it in cases where it might be appropriate. Otherwise, I guess an appeal tip I would mention is just pay attention to the special lens of analysis that we have to look at trademark applications through. And by that, I mean, we are very much looking forward to what a trademark registration and the four corners of that would look like. So that's the mark that has been presented to us for registration and the identification of goods and services. So we get a lot of ex parte appeals where lawyers are arguing to us, well, here's the special way I actually use this mark. It's always with our house mark. It's not part of what we put in the application, but we use it in this different way, and that might help us get around a likelihood of confusion site. Or they'll be telling us, well, I've identified, a really broad range of goods and services, but I'm really doing something that's actually a lot more specialized, and that's why I can distinguish it from this other mark on the register that might be a likelihood of confusion problem. And we can't consider that. We have to look at what's been presented in the application. So I think, we end up in case after case kind of having to say, we can't look at what you're actually doing in the marketplace in that way if it's not reflected in what you've given us in your application. So just to bear that in mind, and, not even just at the point where you're briefing before the board, but also when you're putting together your application, maybe you want to think about narrowing, or maybe you want to think about what mark you actually present.
Okay, well, thank you. So, Officer Neerberg, read the orders, read the instructions, make sure you know what you're doing by the time you make your filing, use the actual registration, pay attention to the damages, and be respectful. So Judge Lynch, the pretrial pilot program, the accelerated case resolution, and the appeal tip, all very, very useful. So Judge White, you've given us sort of a peek into the future, but do you have some tips too to add to that list?
Sure. I guess on the future side, I will echo some of the things you heard at lunch from Director Shimabuku. We have the AI guidance that's out now, and two things to keep in mind. The case law is still to be developed on this thing, but on the attorney side, if you feel confident enough in the AI to let it draft your briefs, be sure that your briefs still fall into the land of nonfiction, because some of the AI have a penchant to getting into fictionalized case law and fictionalized evidence. That can cause you problems. On the inventor side, think about how you're going to document what the human aspect is of your invention. I don't know how all this is going to completely shape up because, like I said, the case law is largely to be developed, but what do you think is the thing that your clients need to have as the evidence when you do end up coming before us? these issues are going to be coming in front of us, and what evidence are you going to have to show what your human inventiveness was? So that's something to sort of keep in mind as you're having some counseling conversations with your clients about how AI is going to impact what they're doing going forward. And then practice tips. One thing I like to tell people that's not documented anywhere is when you send us emails through the trials box, which is the way that people communicate with us on various sort of administrative things, we don't get those immediately. I know that sometimes attorneys will send something off to the trials box and think that the judges are going to be right on it. I might not get it for maybe not until the next day. And I know some people have sent things to the box like, we've settled. And some folks have, by the hair of their chinny chin chin, avoided getting a decision going out the door because I didn't get the I've settled email until right before I was about to mail their decision. So you might want to make sure you have some buffer time if there's something that you want us to get on quickly, because we don't get those emails necessarily right away. There's a process where paralegals go through them and then they route them to us, and that's not instantaneous. And then as far as a practice tip, my favorite practice tip that I like to give people, especially newer attorneys, is that your best weapon out there in arguing for your client is the word because. It's not just I win, it's I win because, I'm right because, we meet this standard because. That word because is very powerful in making sure that what you're saying is not conclusory. It's powerful in making sure that you have established the proper factual background for what it is you're trying to put out there. If you make a statement and you can't think of something to because with it, then maybe you need to look at your evidence and make sure you are marshaling the right things so that you can get your case in a solid footing.
All right, thank you, Judge White. Are there any questions out there? We've got yes, right here.
Question for Mr. Newberg is whether his office gets involved in creating educational modules for the Copyright Office. And I ask that question because I have long been concerned that K-12 school districts do not pay attention enough to copyright education. I argued before the Frisco School Board a couple of months ago that they should start educating students about copyright at least by freshman year in high school, preferably by the beginning of middle school, because as we all know, kids start creating copyrighted works once they're out of diapers, and at least by the time they start using social media, they're infringing right and left. So they need, and their parents need to know a whole lot more about copyright than they're learning now. So I wonder if your office is involved in that.
So when you say office, so the Copyright Office gets involved in that. I know they put certain things out. You're preaching to the choir on that sort of thing in terms of getting more educational materials out. Our office, so when you talk about Copyright Claims Board, we are housed at the Copyright Office and we are under the what would be considered the general direction of the Copyright Office, but we are separate, and so we don't get involved with their sort of policy and the thing on the actual just copyright stuff, and they are not allowed to get involved with our individual decisions. So I can make suggestions and they can go, but they actually, it's even more than that for them. They cannot say anything that would suggest you should decide a case one way or the other. But I'll next time we're talking about pushing out information on the CCB, I'll note that.
Excellent.
They rely on librarians for copyright, but as a former publisher, I let them know that librarians do not have the whole truth about copyright.
Yeah, excellent question and statement. I often told my kids when they were living at home, they are out and off the payroll now, but daddy pays for you to go to school because people do what you're doing, so stop it. Do you have a question?
Yes, Judge Lynch, do you have a sense for the cancellation proceeding, whether there's any substantial co-pending litigation going on and whether one is pausing for the other or vice versa?
Yeah, we do indicate to the parties that they need to let us know if there's litigation, for example, going on in the courts, or now we also have the possibility that there might be one of those TMA proceedings that I mentioned in the examining operation that would involve the same registration. So the parties are supposed to be telling us about those, and more often than not, if, there's any possibility that the litigation or the TMA proceeding is going to moot, or even have a substantial impact on the issues that might be before us in the cancellation proceeding, it's likely, but not automatic, that we would suspend our board cancellation proceeding and let those play out first. Occasionally, I think we've had, for example, district court litigation where they'll prefer to defer to us and let our proceeding go forward. So we have done that occasionally, but yeah, in general, I think we would be suspending.
Last question.
Declaration. Many cases, but try and subpoena for business records affidavit to actually prove up a date. They say they're gonna fight.
I think I've seen that particular declaration, I don't know how many times. The Wayback Machine, I think, has become something that we're pretty used to seeing and something we're pretty comfortable with. As far as authentication issues around that, I don't know that that's been as contentious lately as it may have been early on. I think that everybody's pretty well aware of the Wayback Machine and what it does and what that declaration means. So I haven't seen that be an issue as of late. I know that there were some times early on where it was more of an issue, but I think that's becoming more accepted as just, it's something that's out there and it's a tool that people use. And I don't know that that's been a problem lately.
Well, thank you, and thank everyone. And to take Judge White's lead again, we are done because we are out of time.
All right. Thank you to this panel. If you'll indulge me for 1 minute, if you'll let me make 3 final remarks. First, I do want to thank not just this panel, but all of the panel, all the speakers, including Hope, our keynote speaker, for your insightful comments today. But the second point is this event could not be possible without the help of many, many people behind the scenes. Natalie Greco, who's the Director of Programs and Operations for the Tide Center. And then also 2 people who I don't think are here, but Nikki Doust, who helped with graphics and marketing, Winston Fan, who helps with the AV support. But then beyond that, our TIE scholars. So let me just highlight, we have 10 students working with the center now, 2 Ls, 4 3 Ls and 6 2 Ls. So they work with the center. They help us with various projects, but they work the registration table. They stuff the little bags that you got. They do a lot to help us. Let me just mention them. By the way, excellent students, but then they do a lot of hard work to help us. Rachel Gillespie, Ian Johnson, Val Morrow, Serene Ziden, Caroline Brown, Jess Duty, Julia Goodson, Morgan Lang, Laurel McCabe, and Brooke Sutter. So a great group of 10 students. Finally, last thing, thank you for your indulgence. If you like the discussion of artificial intelligence today, then you should come back next Friday, because the Science and Technology Law Review is having a full-day symposium entitled Artificial Intelligence, Law, Ethics, and Policy. So you could follow us on social media. We're on, for example, LinkedIn, and if you want to follow us to find out about that event and others. With that, we're done. Thank you.
Take a picture with you.